There we go. It's working now. Okay, fantastic. Good morning and welcome back to the Health Coverage Insurance and Financial Services Committee. We are going to do work sessions on LD 1117 and 675 today, and we have some language review as well as discussion of a couple of bills that we haven't had public hearing on that we'll be intending to carry over to next year. And then I think we're going to discuss our table priorities as well, although I don't think we have a lot of things on the table. So it should be a short discussion, I think. All right. So I think that's the plan for today. So we will start with introductions, and I'll start with Representative Matheson.
Good morning. My name is Christy Matheson. I'm from District 1, Kittery.
And Representative Connor.
Thank you, Madam Chair. Good morning, everyone. My name is John Connor. I represent House District 58, which is part of Lewiston.
Representative Arford.
Thank you very much, Madam Chair. Good morning. My name is Poppy Arford. I represent District 49, which is the western part of Brunswick.
Representative Evans.
Thank you, Madam Chair. Good morning, everyone. My name is Richard Evans. I represent House District 120, including the towns of Atkinson, Brownville, Dover, Foxcroft, Medford, Milo, Arnorville Township, and Lakeview Plantation.
And Representative Blyer.
Thank you, Madam Chair. Good morning, everyone. My name is Mark Blyer. I represent District 22, which is Leamington and part of Buxton, Stanish, and Limerick.
And Representative Melorano.
Good morning. My name is Gina Melorano. I represent House District 62, which is part of Auburn.
Representative Brooks.
Good morning. My name is Heidi Brooks. I represent House District 61, which is part of Lewiston.
Representative Morris.
Good morning. I'm Representative Joshua Morris. I represent House District 75, which is Turner, Leeds, and Livermore.
Representative Tepler.
Good morning. My name is Denise Tepler. I represent House District number 54, which is all of the town of Topsham, and serve as the House co-chair of the committee.
Okay. And I am Heather Sanborn. I represent Senate District 28, which is half of Portland and half of Westbrook. We are assisted today by Colleen McCarthy-Reed and Darlene Simno. We had left off yesterday by tabling LD 1117 and 675. We're going to talk about those together, although obviously we will vote them separately, and so sort of reopening the work session on both of them at this time. We were notified last night that the Attorney General would like to come and speak with us about the bills, and so I'm going to invite him to join the meeting now. The wormhole is long this morning, apparently.
Yeah.
Very long. There he is. Okay, good. Good morning, Attorney General.
Good morning.
Good morning. We had a long wormhole this morning in our committee, so I'm not sure why it is long some days and very short other days. So welcome to the committee, and we're looking forward to hearing from you on these two bills.
Well, thank you very much, Senator, members of the committee. Yesterday you heard from my Chief Deputy Attorney General, Christopher Taub, and certainly he was in the best position to talk about the legal considerations of the office. What he was not in a position to do is provide some background that I am, because of my position, maybe in a better position to talk about that would not have been appropriate for him to talk about. After yesterday's hearing, some questions came in to me. I appreciated that both of the chairs heard from me and were willing to let me talk a little bit today. So I just have some thoughts that I think bear in on what you heard yesterday from my office. And I would appreciate any questions based on what it is that I might have to say relating to 1117 and 675. So hopefully briefly, I just do want to provide some context around the legal advice that was given. We reviewed this legislation early on and had reached out, provided some advice to the sponsor on how it is that these two bills could be best distinguished from what it is that we had researched became of statutes like this in other states. Part of the job in the office is to try to help members with questions that they have. And so our goal, recognizing that there was likely to be litigation, was to make sure that this legislation was as defensible as practicable, so that we might see a different result in the event that this legislation passes and it's challenged. In many ways, some of these discussions may have motivated the what's before the committee now in the form of amendments. So improving the bill even beyond what it is that this committee heard was made, efforts that were taken to improve upon what happened in Maryland, what happened in DC. We, as you heard yesterday, but I guess I want to highlight, and maybe I can talk a little bit more candidly about, we are prepared to provide a defense to these pieces of legislation if the committee chooses as a policy matter to pass them into law. We know that there's been work done to distinguish from what has been litigated in other states. We are in a different court, which I think was highlighted yesterday, but I think bears repeating that there isn't a clear outcome as to what's going to happen with these pieces of legislation should they pass. And we're clear-eyed that there's going to be litigation. I mean, I think it was made clear at the public hearing. It's been made clear yesterday. This will be litigated because of how important it is that drug companies are able to do whatever they want when it comes to drug pricing. So they are going to fight to make sure that they have that latitude. That being said, we are prepared to defend that. These challenges come all the time with litigation. When I served in the legislature in my first term as AG, it is common that at this level, there will be threats that there's going to be litigation. There was threat to litigation around the a la carte bill that the legislature passed last session. We litigated that. We had given certain advice at that time as to how it might work out. It worked out a little bit differently than how we had indicated. But again, there were threats. We were able to provide some defense. Same with the internet security provider bill that passed, the privacy bill that the legislature passed. It was only the second in the nation to do something like this. The first that did an opt-in. Threats that was going to be litigated. We have prevailed so far on the litigation relating to that bill. So, I guess I say all this because we understand there's going to be litigation. We know how to work to limit any sort of negative impact to the state. So the attorneys here in the office do a really good job at working a case to limit attorney's fees that might end up being owed if a statute is not able to be defended. So I say all this because I want to frame up that this is a policy decision for the legislature. We believe we can put on a defense if the legislature passes these bills. And this is something that I can say that an attorney in the office would not be able to say. So I appreciate the opportunity to have this time before the committee to provide that flesh to what you heard from my office yesterday.
Thank you. Thank you, Attorney General Fry. Representative Morris has a question.
Thank you, Madam Chair. I actually have a couple questions if you could touch on for me this morning, Mr. Fry. Number one, yesterday the attorney, and I understand maybe he didn't have the, what you're saying is he really didn't have the authority to speak on this, but he pegged the chances at about 50% success. So I want to know where you think the chances are if we pass these laws. And then number two, if you can talk a little more about the a la carte bill and what happened to the state there. As I understand it, the other side waived the attorney's fees.
Yes, so thank you, Representative. So on that first question, you heard from Chief Deputy Attorney General Taub yesterday that this is not a slam dunk win. It is not a slam dunk loss. There is a defense that we can make, and it is not clear how the differences that have been built into this bill from what happened in a completely different circuit, it is hard to say exactly with precision how this case is going to work out. So he gave you a percentage. I'm not here to dispute that percentage or provide a different percentage. I rely very heavily on the expertise of the talent here in the office. What I want to highlight, though, is that we have identified that we can put up a defense to these bills if the policy decision is to try to provide Mainers with that relief. On the ISP, on the a la carte issue, there were two different issues that were raised, right? There was a First Amendment issue that at the front end, we thought that the state would prevail on. There was a preemption issue that we thought that the state would lose on. We litigated it. It actually ended up being the opposite, where the state lost on the First Amendment ground, which is where the attorney's fees exposure came in. We won on preemption. The state won on preemption, and we litigated that through the First Circuit to get the answer there. And it was negotiated that attorney's fees would not be owed in that case. And that's an example, by the way, of what, I understand that there has been representations from the opponents that attorney's fees, have been obtained in other states, that they would seek attorney's fees. Attorney's fees were talked about with the a la carte case as well, but ended up not being, not having to be paid. So you were right in your recollection of what happened in that case, where to the extent that there was exposure, we were able to work so that the state did not get penalized in that way.
Thank you.
Representative Bleier, go ahead.
Thank you, Madam Chair. Thank you, Mr. Frey, for being here. I almost feel like I'm at a prep rally here. After yesterday's conversation that we had with the other attorney, his opinion, your opinion really are not lining up. And out of my experience being in business and lawsuits, I feel that, the outcome of 50%, considering that they've lost in a couple states, is more realistic. Now, after speaking to both chairs coming forward to this committee to say that, it's not that big of a deal, we can win this, we can come up with a defense, I agree. You can come up with a defense. The issue is, can you win the defense? And that's where the issue is. And I don't think that you can. And so, again, my problem lies that this has already been challenged in other states. They've already lost. Do we want to spend taxpayer dollars to litigate something that the potential of winning is slim to none? And in my opinion, is that, it's easy to say that when we don't have to write a check out of our personal pockets, but if we had some real responsibility that if we had to write a check for this, we probably would make a different decision. So I'm going to rely on a decision that this is not a winnable case, in my opinion. I do not want to take taxpayer dollars to litigate something, even though you can come up with a defense. I think that this is bad policy going down a road that brings the state to a definite litigation. You already said we're going there. And so that, to me, this is not the right direction for this community to go on this particular legislation.
Thank you, Representative Bleier. Is that a question for Attorney General Frey or just a work session comment?
I feel as though that, I guess it's not really a question, it's a statement that I feel that we have two people from the same office with two separate opinions.
Okay. Attorney General Frey, do you want to address any aspect of that?
I regret that that's what the outcome was. I have not disputed what percentage he gave. I understand the point of view that was given about how that is being evaluated from the perspective of a person who's going to vote on this bill. I am not contradicting anything that that my office said yesterday, but I am the one who gets to talk about the policy question that's before the committee. It's appropriate for me to talk about that. That's why you're hearing from me. It would not have been appropriate for an attorney in the office to come in and talk about, you know, that policy question. So I'm not here to dispute anything that was said by my office yesterday.
Okay. Are there any additional questions for Attorney General Fry? All right. I don't see any. So I am going to thank you for joining us.
Thank you very much.
Back through the wormhole. Okay. There are other attorneys in our Zoom meeting. If there are folks on the committee who want to hear from other attorneys, there's an attorney from Nashby and there's an attorney from Pharma, who are both in our meeting. I'm going to leave it to the committee to let me know if you have questions for those folks. Please raise your hand. All right, Senator Brenner.
Thank you, Madam Chair. I would like to hear from the attorney from Nashby, please.
Okay, so her name is Rachel Sachs. I'll bring her in now. Good morning, Ms. Sachs. Thank you for being with us.
Thank you, Senator. I just want to clarify, I'm a law professor at Washington University in St. Louis. I do work with Nashby, and I've helped to author a policy brief on a different, though related, drug pricing bill on the use of international reference pricing at the state level. So I'm very familiar with many of these legal issues as they relate to these bills, but I'm not a practicing attorney on behalf of Nashby, to clarify.
Thank you for that clarification. I apologize for mislabeling you exactly, but okay. Senator Brenner, do you have a question for Ms. Sachs?
Yes, thank you, Madam Chair. And thank you, Ms. Sachs, for being here. I'm wondering if you could speak a little bit to the issue of the constitutionality of these two bills.
Yes, absolutely. So there are two primary issues that were raised in yesterday's working session. One on the patent preemption issue that relates only to the unsupported price increase bill. And then the dormant commerce clause issue is related to both, as I understand it. To focus on the dormant commerce clause argument, I do want to note that, as was mentioned yesterday, the pharmaceutical industry will always make this argument as it relates to bills like these. I'm reminded of what happened in Minnesota, where the state legislature worked to create a compromise bill with industry, and then industry still turned around and sued to invalidate the law. So there is no avoiding the threat of litigation entirely. But more generally, I do want to say that the Dormant Commerce Clause is about protecting commerce against economic protectionism. It's meant to be about limiting states' efforts to protect their own in-state businesses from out-of-state competition. That's not what's happening here. This is about the extraterritoriality line of Dormant Commerce Clause precedent, something that Justice Gorsuch has referred to as, I believe, the most dormant part of the Dormant Commerce Clause, suggesting that it's really not an important part of the doctrine today. And I want to note that if it is true that a law that has the incidental but not express purpose of regulating out-of-state transactions would run afoul of the Dormant Commerce Clause, then most state consumer protection laws relating to price gouging, relating to other forms of taxation and the like, would run afoul of the Dormant Commerce Clause. And so there are many, many examples, including a recent one out of the Sixth Circuit of courts upholding price gouging or other laws against Dormant Commerce Clause arguments like these, saying that even though there is an upstream chain of commerce that involves out-of-state transactions, where the law is focused on in-state transactions and is specifically tied to its impacts on in-state consumers, a law like that will survive a Dormant Commerce Clause challenge. And as I understand it, that is the goal of both of these bills, and the way in which they've been drafted is different in kind from the Maryland bill, which was struck down. I'm happy to pause, or should I go on to the patent preemption question?
Are there questions on the Dormant Commerce Clause argument that Ms. Sachs has just made? Representative Matheson.
Yes, thank you so much, Madam Chair. Could you just give me an example of when that was an effective legal battle where the dormant clause basically?
Yes.
Yeah, can you just give me an example, please? That would help.
So I'm looking at a Sixth Circuit case decided in April, a few weeks ago, that was on the subject of a price gouging law relating to online sellers who obviously don't have a business selling only to the residents of Kentucky, as was involved in this case. They sell to people in every state. And the question was regulations about the sales of products to Kentucky consumers, whether that was a violation of the Dormant Commerce Clause, because it could implicate sales that were also made to people in other states, was the argument that was made. And the Sixth Circuit held that the law was not a Dormant Commerce Clause violation, in part due to its nexus to in-state sales, and in part due to its merely incidental effect on out-of-state commerce. And to be clear, that was not a drug pricing bill.
Okay. Are there any additional questions for Ms. Sachs regarding the Dormant Commerce Clause? All right, I'll have you move on to the patent preemption question.
Sure. So here I just want to focus on the opinion of Judge Gallarza in the Bio versus DC case. So as a reminder, in that case, the District of Columbia passed a law that explicitly regulated the price of, as the text of the statute said, a patented prescription drug. The text of the law was focused entirely on patented drugs. And the Federal Circuit did indeed say that that was preempted by the federal patent statutes. And then in denying the rehearing en banc, Judge Gallarza, who was the author of the panel opinion in that case, he said he specifically disagreed with the statement of another judge on the court who expressed concern that his opinion would prevent the regulation of all prices, including those of some products which were patented. And he said, quote, whether future efforts of states to regulate drug prices, which, for example, did not only target patent drugs or did not as significantly or directly undermine the balance of the federal patent right, would also be preempted, is a question that remains for another day. And so that, I believe, is the goal of the draft legislation here, to say that we're not focused explicitly or only on patented drugs. We're focused on all drugs that raise these significant pricing considerations, some of which will be subject to patents, but others of which will not. And if it is the case that laws which incidentally, but not only, have an impact on products involving patents, once again, there are many, many laws throughout this country, and presumably including in Maine, would be impacted because so many of the consumer products we use today are covered by patents, at least in some form. So even the judge issuing that ruling said it would be a different case if the law was broader, and this law, the unsupported price increase law, is in fact broader. So again, I'm not saying that this is a 100% win for the state. What I am saying is that in drafting the model legislation, NASHB learned from precedent and used precedent as a guide in updating the proposal in a way that is more likely to insulate the law from the challenge that industry is going to bring.
Representative Tepler.
Thank you, Madam Chair, and thank you so much for being here, Professor Sachs. my question takes us back to the Dormant Commerce Clause issue. So I understood your argument, but my concern is that the transactions we're talking about here are actually not in state. They're out of state. They're transactions between manufacturers of drugs that are located out of Maine, and wholesalers who also are not located in Maine. The end product of the transaction may be in Maine exclusively, but the initial transactions, particularly between the manufacturers and the wholesalers, are taking place outside of Maine.
Yes, I believe that to be a correct statement, although once again, I've only seen previous drafts of, I believe, 675. And I'll have to take a look at the amended versions, which I know were discussed yesterday, to see if there are differences. But more generally, I think what I would say is that the Dormant Commerce Clause is not intended to prevent states from regulating goods or services merely because they originated out of state, especially for smaller states, of which there are many in this country. It would almost always be the case that the upstream transactions and the manufacturers are located out of state in a way that would really bar states from enacting consumer protection legislation of this type, not limited to the prescription drug space.
Are there any additional questions? All right, I have one, Ms. Sachs. Is there any precedent anywhere for an anti-withdrawal provision?
I'm happy to look further into that and get back to you. Today, I was only focused on these questions of the Dormant Commerce Clause and patent preemption, but I'm happy to watch those portions of yesterday's hearing and to get back to you.
Okay. Are there any other questions for Ms. Sachs? All right, not seeing any. We thank you for joining us this morning. I'm going to send you back through the wormhole. And I am, is there anyone who wants to hear from the attorney for pharma? Representative Morris, is that you asking to hear from the attorney for pharma? Okay.
Yes.
Good morning, Mr. Reichel. Go ahead.
Thank you. Well, let me just respond to a few points. I think Representative Tepler's question, if I'm remembering, actually no, I think it was Senator Sanborn's question about the anti-withdrawal provision. That provision is a Dormant Commerce Clause problem as well. And that is actually an area where this bill goes much farther than the bill that was struck down out of Maryland goes. The Maryland bill did not have a provision that required out-of-state manufacturers to physically transport their goods into Maryland. And it was still struck down. So this bill is actually more aggressive in that way, and in my view, more problematic from a Dormant Commerce Clause perspective, because it expressly tells out-of-state individuals or companies that they must create a product, they must put that product on a truck, and they must bring that product into the state of Maine. And if they don't, they will be subject to a very significant fine. So the bill is unconstitutional. That aspect of the bill, at a minimum, is unconstitutional, and I think it brings the whole bill down. With respect, and I think it was Representative Tepler's question, I think she had the exact right question with respect to the portion of the bill that imposes a fine on the manufacturers. She was correct. The transactions at issue occur out of state between out of state actors. That is not, as Professor Sachs said, that is not an incidental or upstream impact. It's a direct impact on an out of state transaction where at least one, if not both parties, are out of state actors. So again, the Dormant Commerce Clause does not allow for states to regulate purely out of state transactions in that fashion. And the bill does that. I saw the amendments to the bill from a few minutes ago. It does not, those amendments aren't aimed at fixing that problem. Similarly, the amendments to the bill are not aimed at and do not address the patent preemption problem. Professor Sachs quoted from a portion of the Federal Circuit order, but the order that she was quoting from was not the actual binding precedent. She was quoting from an order denying en banc rehearing of the of the Federal Circuit decision. So the Federal Circuit decision that we discussed yesterday is binding law. It would be binding on the District of Maine because the Federal Circuit's precedent in matters of patent are binding on the federal district courts. And so the quote that she raised doesn't undo that in any fashion. I guess what I would say is, I'll reiterate what I said yesterday. This bill clearly regulates patented drugs. And in doing so, it seeks to upset the balance struck by federal patent law. The fact that it also regulates other non-patented drugs doesn't mean that the violation of patent law is okay. It just means that there may be an additional problem.
Representative Tepler?
Thank you, Madam Chair, and thank you for being here, Mr. Reichel. Mr. Reichel, I'd like to kind of go back up to, say, 10,000 feet and ask you a big question. I really would like to protect people in Maine from excessive price increases for pharmaceuticals, both generics and on patent medications and recently off patent medications. How would you suggest that I do that?
Well, it's a laudable question. It's obviously a goal that is an important goal. I am here today purely from a legal perspective. That's why Pharma asked me to be here, was to give my advice and views as an attorney from a constitutional perspective. My focus is, my own personal focus is not on the overarching policies that are at issue here, but just on the legal mechanisms that have been used to implement those policies. So I'm sure there's someone from Pharma who would be more than happy to answer that question, but I'm not in a position to do that for you today.
I'm going to disagree because you are specifically pointing out legal challenges to the policy. So I'm saying to you, sir, what can we do to eliminate those legal challenges to the policy?
Yeah, I understand. Well, I guess what I would say is this bill as drafted, the way it is structured fundamentally, I don't know that there is a fix from a patent preemption or a dormant commerce clause perspective. Obviously, the menu of policy options that might exist to lower drug prices are multiple. I know you've got a number of different bills in front of this committee and potentially others in this legislature that might accomplish that. But the mechanisms used in this bill, I don't think are fixable from a constitutional perspective.
Thank you.
Okay. Are there any additional questions for Mr. Reichel? All right, seeing none, thank you for being here. I'm going to send you back.
Thank you.
Put my headphones in and they're not working. There we go. Okay. All right, so next, I think I will call upon the sponsor of, yeah, those aren't working. I'm going to call upon the sponsor of one of the bills. There, can you guys still hear me? Yeah, okay. So I'm going to call upon Senator President Jackson. He is the sponsor of one of these two bills, so I'm going to bring him in. Good morning, Senator Jackson. Go ahead.
Good morning, Senator Sanborn, Representative, members of the committee. I appreciate having the opportunity. Sorry I wasn't able to join you yesterday for the discussion, but I just wanted to follow back up for some of the conversations that's been through yesterday and through today. You know, we obviously took this issue on. It's been something that, you know, I've been very interested in throughout my entire time in the legislature. You know, we work with the Attorney General's office, and, you know, up until, well, not even yesterday, the Attorney General's office said that, you know, with some of the changes that we had in the bill, you know, they can defend it. And, you know, not just a token defense, but a defense. I don't think there's anyone in the legislature or really in the world that doesn't think that these issues are hard to tackle. Farmers got an amazing ability, an amazing amount of money to affect things, and they do. And they're always going to sue. I mean, I've been here, this is my 17th year. Every piece of legislation ever introduced to even do a little bit of good, we've been, you know, threatened to sue. Actually, there's more than that. I mean, there's all kinds of companies that argue all the time that they'll sue, and obviously that makes the legislature not as apt to want to do things. But this is an issue that, I mean, I don't think any of us should ever be afraid of pharma. I mean, this is their go-to move. You know, pharma doesn't hire a lobbyist, they hire all the lobbyists, they hire all the law firms. Again, the Attorney General's office said that they can defend it. And, you know, that's, you know, really important. I mean, we just got information from health data, you know, we just got it. In 2019, 53 generic drugs, they increased 109% from 2019 on generics. And this is not the 30-cent bills that we referenced yesterday. These are the $2.50 bills, the minimum $2.50 bills, which is an astounding amount of an increase. So, I mean, I think we all know that this is going on. I mean, our constituents all know that's going on. And, you know, I think it's important. Even if there seems to be some concern about the assistant AG yesterday and the AG today, let's assume that the assistant AG yesterday is 100% accurate, 50-50. Well, I think that's probably better than where we are for our constituents that have 0% chance of having anything happen for them if we don't take the 50-50 opportunity. Because it'll continue just like it has with 109% increases year to year. And so, honestly, I mean, I got into the legislature because of issues like this. You know, and I've made this argument a lot, and I think this is a great place to make it. we're all sitting here right now with government-sponsored healthcare, and we may not be interested in making a change for people out there in Maine, or trying to make a change. I got to tell you that, the idea that resolve or delay just means that we're going to allow families to go longer paying insane prices, and I just don't have any patience for waiting on something like this for anybody that talks about the worry of being sued. I would rather have our Attorney General's office, which was the biggest law firm in the state of Maine, take this issue on so that people in the state of Maine know that we're at least trying to affect change that is meaningful for them. Again, a 50-50 opportunity, I think, is great odds when you're talking about a monopoly the size of farmer across this country. And I honestly don't know what else, what else to say about this. I mean, again, if we can't, as a legislature, go forward and do something to help our constituents, at least give an opportunity, then I really don't want to be in this legislature. And that might actually be an incentive for some of you to vote against this, because I don't see any reason to be here and look other people in the face out there that are struggling every day with the cost of medications. While I'm getting government-sponsored medications, we're all getting government-sponsored medications, and I'm supposed to go back and look them in the face and tell them to wait. That we're not willing to take on pharma. I guarantee you, there's nothing that's going to happen next year that's going to make this any easier to take on big pharma. So in the end, and this is my bill, if the committee's not willing to vote in favor of going forward and taking an opportunity to have a chance to lower the cost, or at least have somebody look at lowering the cost, then I would rather you vote straight out not to pass and not put anyone out there thinking that we're actually going to do something, because we're not going to do anything next year either. So that would be my hope, is that people would actually either vote in favor of it, and knowing full well, and I know full well, that they're gonna sue us. They're always gonna sue us. There's always somebody out there that's gonna sue us. Let's take that opportunity with the Attorney General's office that at least believes they have a shot, as opposed to going back to our constituents and saying, oh, we're actually doing something to help you, but just wait another year, get another 109% increase. I don't want to do that. I'm certainly not going to go back, and I'm not going to serve the legislature that operates that way either. So thank you very much. Look forward to your vote.
Representative Tepler.
Thank you, Madam Chair, and thank you for being here, Senator Jackson. And I certainly appreciate your concern about the effect of drug prices on Maine people. I mean, I share that concern. I, in fact, take quite a few drugs, and the prices certainly change more often than I am comfortable with. And I agree, we shouldn't be afraid to take on pharma. I just really believe that given a bit more time, personally, we could make these bills more likely to succeed. And that is really my concern. My fear is we take them on and we can't win. And that's really frustrating. I want to win. I want to take them on. I want our state to be able to control how consumers are affected by excessive prices for drugs. Totally. But I am worried that this bill will not succeed at that, or these bills, I should say. So I hear you. I'm with you conceptually. I am very concerned about the effect of these bills, sir. I appreciate what you said.
Representative Tepler, I appreciate, and I know you're with me in spirit also, but let me assure you that we will not pass anything next year, because in an election year, it'll get even tougher, the pressure will be even harder, the money being spent will be even more, and we'll lose even more support for this, regardless of the legal aspects of it. This bill has already become very political. We have a real challenge between the second and third floor right now in this legislation. And that's part of the reason why we're at today. It'll be only worse next year. And the money and the lobby that we'll see, and I've seen this time and time again throughout my 17 years. That's why I'm more, and I think probably Representative Blyer is going to ask a question about taxpayers, but maybe not. But let me address that too. I would bet that if you get the people out there that are being affected by these 109% increases to ask them, I bet you they'd spend their last nickel as a taxpayer to go after Big Pharma, because there's nobody in this country that's making people's lives any harder than these drug companies. And so I believe wholeheartedly that taxpayers are more than happy for us to go after them. I think they want the legislature to actually do something on this issue, work for them instead of the healthcare industry and the big pharmaceutical industry. So there's nothing that's going to magically appear between here and there next year that's going to make people feel any better. Or these guys, you've asked them, how to make this bill better. They don't want to make it better. They don't want any state or any federal government to actually have any control over them. And so we're going to play this game until enough of us are willing to take the step forward to actually trying something. I'm not saying we're going to win. I never once said that. But we're at least taking an opportunity to make a difference. And I think the main taxpayers, the main constituency that we all represent are going to think a lot more about that than sitting around and saying, well, it's not good.
Representative Blyer.
Thank you, Madam Chair. Thank you, Mr. President, for being here. I guess my question to you, Mr. President, is I get your point. I know you want to try to do something. The question is, though, 50% at best. So if I look at that as a numbers person, we're probably talking 30% chance of winning. Now, having said that, how would you want me to answer my constituents that, yes, I passed legislation that brought the state of Maine into a lawsuit with a chance of 30% winning. And by the way, I spent $2 million of your tax dollars in doing it. So I hear the point that you're saying it's going up 109%, but this is not a lawsuit that hasn't been tried. It's been tried and lost. So that's the difference here. It's already been proven that this is not a winnable case, but yet, what do I tell my constituents by passing this bill that, you know what, I'm going to spend $2 million of your tax earned dollars as well to try because I want to do something. So I guess the question is, sometimes just because you can doesn't mean you should. Would you fall in that same?
Senator Jackson, go ahead.
If it's 50-50, President Blyer, I think that's amazingly good odds compared to what we're going up against. These guys own everything. They hire everybody. They get every law firm. I mean, to have a 50-50 chance is unbelievably good odds against this. And so really honestly, at this point, I'm not talking to the legislator or Senate President. I'm talking about somebody that lives in Maine and can't stand to look at other people in the face, to talk to them about what they're paying for their prescriptions. I mean, you guys had testimony of people that couldn't get their drugs because of the cost and died because of it. I mean, I think a 50-50 opportunity to save somebody's life is an incredible loss. That's like something you never see. And so, $2 million, I've never said that that's not a significant amount of money. But I'm telling you right now, I think the people out there that are affected by this, which is all of us, if you ask them, would you gamble on a 50-50 chance or even a 30% chance to take on an industry that is making obscene profits off the backs of the American public for 30, 40 years, whatever it is? To me, this is a no-brainer with the people that, you're from Fort Kent, I'm from Fort Kent. Stop on the street anywhere, stop in BJ's and ask somebody, do you think that we should take on Big Pharma because of the obscene amount of money? I mean, that is something I am so clear about that there's, well, I mean, I don't know how else to explain it, but every ounce of my soul knows that the people in the state of Maine and the people in this country want action on a greedy, corrupt system that is continually perpetrated on the people, and that's why I want to serve in this legislature. But if we can't get to a point that will take on somebody that is so consistently looked at like the scourge of the world, then I don't really know what I'm doing here. I really don't.
All right, follow up, Madam Chair.
Yes.
Thank you very much. So you're right. So let's say that, I mean, 50-50 in my opinion is not good odds, so let's say that we win. What's the repercussions of winning now? We can't go up to a company and say, okay, we won. Now we're going to control what you make, how you make it, how you sell it, how much you spend on it. At the end of the day, there's repercussions to winning something like this. Could it be less investment in coming up with newer drugs, things of that nature? I mean, there's a repercussions to winning this case that may in some turn work against us as well, even if we were to win. So yes, I agree. We might be doing something, but is it the right way to go? And I in my opinion, I do not think so. So I'd like to hear your opinion.
So the right way to go, I mean, to have some control over this as opposed to absolutely any control, I definitely think is the way to go. I mean, again, the Attorney General's office is the biggest office in the state of Maine law firm. And to have them at least trying to work to get these guys under control, I think is a huge stick to bring out. The lack of zero enforcement or oversight is what's allowed this to happen for so many years. And the monopoly system that they have, and you ask about research and development, I've been hearing that my entire life. I mean, it seems like the United States is going to be the country that does all the research and development while every other country in the world has lower cost drugs. The rules of the game that they have in the United States is so stacked against the people here that I'm shocked that people haven't actually revolted because of the insaneness of how this works for us, as opposed to, and again, I don't want to pick on you, Representative, but you looked across the border and for Canada and Claire, we know that these drugs are being sold all across the world at a much lower price, but because of the way that the system is here in the United States, we're picking up the tab on everything. And so I absolutely reject the fact that they won't do the research and development because of something like this. I would say that instead of making outlandish, crazy, foolish, insane prices, they'll just be making astronomical prices under this scenario. Maybe that won't even change, but at least we'd have an opportunity to have some enforcement mechanism actually go after $109% increases from year to year on generic drugs that are supposed to be off patent. The research and development's already been done and are supposed to be much lower cost, but because we don't have a way to actually enforce the prices, they charge whatever they want.
Just a follow-up comment, Madam Chair. I think that Canada subsidizes their prescription drugs, so that's not a fair comparison. That would be my only comment.
Okay.
I actually don't think so. I actually think that Canada does the ability to buy drugs as one unit and gets them from the very same places that we're getting them in the United States. They're actually the exact same drugs. If a prescription, if medication actually is in the United States and goes to Canada, it can't even turn around in 1 hour and come back to the United States because the FDA has ruled at that point it's not safe anymore. I mean, the rules are completely upended on this, and the American public are the ones that are picking up the tab.
Okay, are there any additional questions for President Jackson? All right, seeing none, thank you. And I'm going to send you back through the wormhole, as is our custom here. Okay. So now unless there's anyone else who the committee wants to hear from, I think we're going to move on to the committee discussion portion, or a motion would be in order as well. Representative Malvarano.
Thank you, Madam Chair. So I just wanted to say a few things. One is, of course, there's no doubt here that the pharmaceutical industry and industries are a formidable opponent. They have a very active, very influential, very powerful lobbies, effective lobbies, as we've shown, I mean, as we've seen. And the result of that, of course, is that, you know, you don't see the kind of grossly inflated prices in other countries that USA consumers see here. And the pharmaceutical companies just don't get away with it in other countries. And the reason for that is because of government intervention and proper government regulation. You know, I think that our constituents know the problem. They know that they have been raked over the coals by this industry. According to the Kaiser Family Foundation, 79% of Americans, according to this poll, believe that pharmaceutical prices are unreasonable. The public wants and needs us to act. And I think it's also time for Maine to signal to the federal government that if you're not going to act, we will. I think it's time to take bold action on behalf of our constituents. For that reason, and I'm talking about both bills, LD 1117, LD 675. I think we're on 1117 right now, of course. I do want to move ought to pass as amended with the most recent amendments done by us yesterday, as well as with the sponsor that Colleen sent us that.
Okay.
Yep.
So there's a motion to pass as amended on LD 1117. Is there a second? Are those hands second? Representative Arford, that's a second? Yes, okay. So it's been moved by Representative Malvarano and seconded by Representative Arford. Representative Malvarano, were you done speaking? I just wanted to get the motion clear, but I don't want to interrupt you if you weren't done speaking.
Yes, thank you, Madam Chair.
Okay, Representative Tepler.
Thank you, Madam Chair. Oh, shoot, sorry. I will ignore my telephone. Hopefully you will be able to as well. So I would really love to hear from Karen Lee Harrington of the Maine Health Data Organization, if she's available, to talk about whether there are some alternative ways to challenge big pharma that might be effective and not be subject to Commerce Clause dispute. So that's just something I would like to consider. I don't know if Ms. Harrington is with us or not, but if she is, I would love to hear from her on that possibility.
I can bring her in. Senator Brenner, do you have your hand up?
Yes, thank you, Madam Chair. I'm wondering if we can also have her colleague, Jim Jones, present.
Yes, sure.
Thank you.
While we're waiting for Mr. Jones, can I ask my question?
Yep, he can hear you now, so go ahead.
Morning.
Morning.
Thank you. Good morning. Good morning. Thank you both for being here, and thank you, Madam Chair. I would love to hear from you all who deal with a lot of our data around price changes in pharmaceuticals for Mainers, whether you have an alternative way you might suggest for us to take on these price increases that Mainers are facing. Because I certainly want to try to help Mainers who are facing serious price increases.
So good morning, Representative Tepler and Senator Sanborn and members of the committee. Let me just start off by saying, if we knew the answer to that, we'd be millionaires, billionaires. You know, I think as you've heard over the last couple of days and probably years, as you've been struggling with these very real issues, there is no silver bullet, and there are a lot of challenges. And so I guess what I would say is, from my perspective, what I can offer is information. And I think that you have set us up with the policies that you've passed to have access to the data. And now what we need to do is, you know, we have 1 year's worth of data around price increases. And there are some really interesting pieces of information that we have been able to analyze with a small amount of data. In year 2, we're going to collect a lot more data. And so I think, you know, what we can bring to the table, we are not in a position to help you figure out this very challenging policy matter, but what we can do is bring you the data and the information. And you know, you've got a pharmacy accountability board, and there's a broad group of stakeholders that represent that board. And we can certainly bring them information and help them maybe with thinking through different policy options to get to this issue around increases in affordability. I wanted to just quickly put a couple of things in perspective. As President Jackson had mentioned, you know, from the small sample of data that we got in our first year report, just to give you a sense, the average increase as a percentage was 109%, as Senator Jackson said. And in terms of what that represents in a dollar amount, the average dollar increase was about $287. And the minimum part of that was about $2.45, but the highest increase was almost $5,000 on one drug. And so, you know, this is information that we want to drill down into and understand, what is the impact? How many people? What is the class of the drug? Are there alternatives? Because maybe, you know, some of what you can legislate without some of these legal challenges are issues around formularies and directing people to different drugs and not using, you know, some of these drugs that have these ridiculous increases. So anyways, so I'm sorry, Representative Tepler, that we don't have the answers, but what we can do and we will commit to is we can help bring transparency. And I'll just say this one last thing. In order to give you the kind of information you want, I think to make the kind of policy that you want to make, you need to enact the legislation that allows us to be more transparent with this information. So I'll end it there. I don't know, Jim, if you want to add anything, but I think that's, you know, that's the best that we can offer right at this point.
I would just reaffirm what Ms. Harrington was saying, and just the passage of 686 is imperative for us to be able to drill down further. And beyond that, I think that it is important as we drill into things further that we look at the net prices. The WAC costs are definitely the the driver that we can measure across the board. It's the level playing field for triggers. But we need to be able to look into the specific rebates that are happening, and where, we may find that some of these drugs that are going up incrementally, the majority of that is going to rebates, and that's the underlying issue that we need to look at from a policy perspective.
I want to thank both of you, and I completely understand Ms. Harrington, and in some ways apologize to you for putting you in that spot, but also really appreciate your being here and offering us the information that you do offer.
I'll just say quickly, no apologies needed. We are so excited that this data that you've authorized us to collect will be able to help with these issues that impact all of us in one way or another. So I'm super excited about what opportunities lie ahead.
Thank you.
Okay. Are there any additional questions for Ms. Harrington or Mr. Jones? All right, seeing none, I'm going to send you back through the wormhole, and thank you again for joining us this afternoon. Okay. Further committee discussion, and we do have a motion on the table, but open to discussion of either of the bills still, and anything the committee wants to discuss. Representative Arford.
I will support the motion that's before us right now. I support what has already been said by those who also support this motion. And I will add that I was very aware of the issue with unaffordable pharmaceutical for the people of Maine, having served for the last 12 years in the role of representing patients' interests in many different stakeholder groups. And for those people who are listening or will listen to this hearing in the future, I just want them to know that I truly believe this committee has their back and understands the issue. And wherever people choose to vote today, I believe we will continue to work extremely hard on ensuring that everyone who needs a pharmaceutical product has access to it, that it is affordable to them. And these bills before us are the place to start. And I agree, if not today, when will we do this? We must start today. So I invite the rest of my colleagues to vote with us. And if you choose not to vote with us, I truly believe that this is the time to tell the people of Maine what you will do going forward to ensure that pharmaceutical products are affordable for everyone.
Additional comments from the committee. Representative Tepler.
Thank you, Madam Chair. I feel in a very difficult situation with this bill, both of these bills. I do believe that we need to challenge Big Pharma, but I want to do it carefully and with at least some sense that we have a possibility of success. And truthfully, I am deeply concerned that both of these bills are going to be found unconstitutional. Does that mean that we shouldn't challenge them? I guess I'm not certain, but my concern is I took an oath to uphold the Constitution. And if I specifically know that I'm challenging the Constitution in passing a law, is that something I'm comfortable doing? And my conscience is very torn about this because I know that the people of Maine want relief from pharmaceutical companies and excessive prices. I know that, and I want to do the right thing by the people of Maine, and frankly, myself. I depend on a fairly large number of pharmaceuticals for my health. So I have to say that I'm a little disappointed in Representative Arford's comments because they imply that if I don't support the motion on the table, that I somehow don't support dealing with pharmaceutical prices for the people of Maine when I do, but I am torn by the constitutional difficulties posed by this bill.
Representative Bleier.
Thank you, Madam Chair. I think I could not agree with more with Representative Tepler, as she just stated just now. I think that she's absolutely correct. But having said that as well, I feel that the opportunity to win this lawsuit is so minimal that I think, trying to do something is understandable, but going into something that I really feel that will work against the state of Maine and use taxpayer dollars against them is not good for our constituents. And so is there a better way? I don't know a better way, but for me, this is really not the way. This is not a winnable case, and that is where I have to say it's not good for the people of Maine.
Are there additional members of the committee who want to make a comment? Senator Brenner.
Thank you, Madam Chair. I agree also with Representative Tepler, and I have a deep and profound concern and respect for the struggle of my constituents and Mainers with regard to their drug prices. And I have a ton of respect for President Jackson and Senator Claxton for bringing these two bills forward. It's a brave and bold attempt to try to fix a system that's really challenging for all of us. But at the end of the day, I also struggle with the constitutionality of the two bills. And I feel like the work we did yesterday to pass 686 and 120 is the direction that we ought to be going in. We need to be able to take this data, scientifically analyze it, produce policy that really addresses the specific cost challenges that we have. And so I would urge the committee that if you really want to support fixing the pharmaceutical industry and the health system in general with regard to cost and accessibility, we ought to be enacting 686 and 120 as our next steps to figure out the puzzle of how this committee can really make a difference.
Thank you, Senator Brenner. I will weigh in at this point. I've been pretty cautious in weighing in on these bills, but I will say that I, like President Jackson, absolutely ran for office because of healthcare costs and pharmaceutical costs. It's why I've spent 5 years in this committee and why we renamed the committee to make it clear that that is exactly why we're here, to make sure that Mainers have coverage for their healthcare needs and that they can access the medicine and the healthcare that they need at a price that does not bankrupt them. So I completely agree with President Jackson that if you went to BJ's in Fort Kent or if you went to BJ's in South Portland and asked constituents if they want us to take on big pharma, they would say yes. And I completely agree. And in reference to Representative Arford's comments, the time to start isn't today. The time to start was actually in 2019 when we put forward an incredibly successful package of bills that passed with overwhelming bipartisan support, and of which President Jackson was the sponsor of some, and myself and others as well. We in this committee have a responsibility to do more than just scream about headlines, right? The headline is, we took on big pharma. Great, but did we win? Did we actually make drugs cheaper? Did we allow people to actually afford their medications? Or did we pick a fight that we couldn't win, but that sounded good? And that's my concern, is that I wanted this bill to be, these bills, to be something that would really make an impact, would be likely to make an impact for Maine people. I committed in 2019, I said it a lot publicly during our prescription drug battles then, that I would pull on every lever available to us as a state to drive down prescription drug costs. But I want to make clear that I knew back in 2019 that the only levers that I get to pull on sitting in the office that I sit in today are the levers available to a state. There's a lot of times over the last 2 years, not just on prescription drug prices, but frankly on just about everything we talk about in this committee, where I have wished that I held an office at a different level of government. Because what President Jackson said about how messed up this country is with regard to healthcare costs, with regard to healthcare access, with regard to coverage, with regard to prescription drugs, he's right. But we have a federal system in this country that gives me certain powers as a state senator and gives Senator King and Senator Collins other powers as US senators. And so I remain committed to pulling on every lever available to me as a member of this body, as a member of this committee, that is available to me and to us at the state level, whether we're talking about affordable, universal health coverage in a single payer model, or whether we're talking about affordable prescription drugs. We're going to do everything we can, but we're not going to do the things we can't. So I am not going to support the motion. It's been a really, really difficult few months, frankly. We've been talking about this for a very long time. And I instead, when I vote against the motion, the report that I will suggest on both bills, they're slightly different, but on both bills will be to ask the MHTO to give us the ability to name and shame the pharmaceutical companies, whether they be generics manufacturers or off patent or brand name drugs, that they will give us the data and the names, which 686 will allow them to do, and that they give us dollar amounts. So it'll be a resolve on both of these bills that that would be my report, and it would ask MHGO to basically do an economic analysis of the increases in prices, to add names to their report, to add dollars to their report that are specifically tied to the utilization of those drugs in Maine. So we know how many people are on a given drug. We know how much it went up. You can then do the math to figure out exactly what the economic impact of those price increases is. And I want that to be headline news, and I want names attached. And to me, that's a lever we can pull on. We can name and shame if we pass 686. If we don't pass 686, we can't do that. If we don't pass LD 44, I don't think we can do that either. We need that. We need the context, and we need the ability to name and shame these companies. So that will be my report when we vote on each of these two bills. I have spoken to Ms. Harrington, and she let me know that she thought some of that financial impact data and the analysis of those price increases in the past can be available for next session. And so the timeline would be that we would have those things available next session. Now, I want to make clear, it's not because I think we can then go ahead and pass 675 or 1117. I don't think that those particular that particular lever in either of those two bills is really available to us from a legal perspective, and the Constitution's not going to change by next year. But what it allows us to do is to truly name and shame and assign a dollar amount to the costs that are being imposed and to the profits that are being reaped from Mainers. And that's the next lever that I think we have available to us. I wish we had more levers, but in our federal system, I think that's what we should do next. With that, I guess I'll stop there. Is there any other member of the committee who wants to make a statement? Representative Evans.
Thank you, Madam Chair, and thank you for your words. I appreciate your words. I appreciate all of the comments made by members of the committee. I think everybody is passionate and concerned about where we go from this point. I too believe in the Constitution. As a former Air Force commander, I have taken the oath of office to support and defend the Constitution of the United States, as well as taking the state constitution. And part of the process, or one of the responsibilities of a citizen representative, is to keep your mouth open. When you see an injustice or you see a wrong, you have to speak up and identify that. The problem that we are facing now is a problem of big pharma. It's nothing new. We do not know what the challenges will be or the outcomes of legal challenges will be. But we should not be afraid to take that leap. No matter what you do, they're going to make it their objective to challenge you legally. And it was very telling today when the former attorney responded to Representative Tepler's question about what could be done to fix this bill or these bills. And his response was that they will never be fixable from a constitutional standpoint. That I totally disagree with, because I don't know that, he doesn't know that. These things are going to be decided in the court. I am tired of seeing patients in my office at the hospital who are struggling to make ends meet and to get medications. When is it ever going to be a good day to challenge the pharmaceutical industry? And with that said, I will be supporting the motion as presented by Representative Melarongo. And I thank you.
Thank you, Representative Evans. Are there any further comments from the committee? Representative Arford.
I would just like to say one further thing, and thank you for recognizing me, Madam Chair. I think anybody that knows me well knows I would never intentionally say anything to offend anybody, including and especially my esteemed colleagues on this committee. So if my words came out in a way earlier that have offended anybody, I want to go on the record as apologizing for that, because that was absolutely not my intention. My intention is to simply invite all of us as an amazing group of, I believe, legislators fully and absolutely committed to doing what needs to be done to make healthcare affordable for the people of this state. I'm simply inviting all of us to work together on this issue, the issue of affordable medications, pharmaceutical products. And I truly believe this is our very best option for today and for going forward. And eventually, whatever we choose to do as a group, if we don't make the decision today to do this thing, will be challenged in court. because there are millions and millions of dollars on the table that pharma, as an industry, will lose if we prevail and if the people actually are assured of affordable medication. And we actually are able to put an end to the type of price gorging that this legislation addresses. So, you know, I have a great deal of respect for everyone that's on this screen with me today. And I just want you all to know that.
Are there any additional comments from the committee? Okay, seeing no hands, I think we're ready for the vote on 1117.
Representative Quinn is absent. Representative Khanna,
No.
Representative Blair,
You are on mute.
No.
Representative Morris,
No.
Representative Matheson,
No.
Representative Evans,
Yes.
Representative Barford,
Yes.
Representative, I can't say it this morning, Millerano.
Yes, that was
Got it.
perfect, by the way.
Oh, thank you. Representative Brooks,
Yes.
Senator Stewart is absent. Senator Brenner,
No.
Representative Tepler,
No.
and Senator Sanborn.
Oh,
4 in favor of the motion. 1, 2, 3, 4, 5, 6, and 7 in favor of. Are you all going with Senator Sanborn's ought to pass as amended?
No, I am ought not to pass.
can you just go through them, Darlene?
Yep.
And call each person and let them indicate.
Sure. Okay, hold on. OTPA.
I
Okay.
didn't hear the vote count.
Pardon me?
The final vote count.
You say that you filed a petition on behalf of House and Senate leadership. Can you clarify?
Well, the final count was 4 in favor of
Yes,
the
correct. It's
original motion and 7 against it. And now I'm going to pull out the people that want to go ought not to pass. Or not with Senator Sanborn's motion. So Representative Khanna,
I am a straight ought not to pass.
Representative Blair.
Ought not to pass.
Okay, hold on. And Representative Matheson.
I'm with Senator Sanborn.
Okay. And Senator Brenner.
You're on mute.
I'm with Senator Sanborn.
Representative Tepler.
I'm with Senator Sanborn.
And obviously Senator Sanborn. Okay. So now we have 4 in favor of the original ought to pass motion, 4 in favor of Senator Sanborn's motion, and 3 ought not to pass.
Okay. Thank you.
You're welcome.
Okay. So next I will entertain a motion on LD 675. I'll call on Representative Malrano again.
Thank you, Madam Chair. I'll move ought to pass as amended with the most recent revision, please.
Okay. Is there a second for the motion? Representative Brooks seconds the motion. Is there any further discussion on LD 675? Okay, seeing none, we're ready for the vote.
Representative Quint, absent. Representative Khanna.
No.
Representative Blair.
No.
Representative Morris.
No.
Representative Matheson.
No.
Representative Evans.
Yes.
Representative Barford.
Yes.
Representative Millerano.
Yes.
Representative Brooks.
Yes.
Senator Stewart is absent. Senator Brenner,
No.
Representative Tepler,
No.
and Senator Sanborn.
No.
Okay, 4 in favor of the motion.
And I think that the reports are the same split as last time.
Same split as last time.
Yes.
And
Okay.
Colleen,
So
just to
it'd be-
clear, sorry, go ahead, Darlene.
Representative Blair, Representative Connor, and Representative Morris.
Yes.
Okay, just double checking.
So Colleen, I think it would be 2 separate resolves, and one would be focused on generics and one would be focused on brand name medications. Because I think the brand name math needs to take into account net costs in a way that I think the generics is a little bit more straightforward. So I think that the brand name report, for example, might need to refer back to sort of unsupported price increases that would be determined by an independent database or something like that.
Okay.
Because that's where the net costs piece comes into play.
Yeah, that was what I was going to ask, if you wanted to use the triggers in the bills as to how they evaluate the dollars and cents and the differences.
Yes, I do. And I want to use the amended trigger
in the generic bill.
Yeah, generics bill, so that it mirrors the generics trigger in
686.
Well, I think it's in 1120, but
11, yeah, perfect. Yep. Okay, thank you. That's what I understood, but I appreciate the clarification.
Okay. Is there any further comment on any of this? I think we're done with this piece, but just wanted to wrap it up. Okay. Thanks, everybody. That's been some tough work, and thanks for hanging with us through a tough slog. Okay. The next thing we need to do is to pick up 2 bills that we have not had a hearing on and have a discussion about carryover. So Colleen, remind us of the first LD number.
Yes, the first one is LD 482. It's an act regarding pet insurance, and Senator Sanborn is the sponsor of this. It would be based on an NEIC model that I understand is still being developed and worked on by the NEIC.
Great. So the rationale for carrying this bill over is that we're waiting for the NEIC to finalize their model legislation. And I knew when I put the title in that it might not be ready for this session, but I wanted to get it in before cloture because I don't think enacting a model act on pet insurance is an emergency that we should have gotten in for the short session. But I knew that a carryover was a possibility if the NEIC model didn't align with our legislative session. So I would urge the committee to support a carryover. Is there any discussion or questions? All right, so seeing none, we will do a roll call. Can't remember what we did.
Yeah, I think we've done roll calls in the past, but if you could do a motion and then have someone second it. I don't know if anybody did.
So I would move to carry over. Is there a second?
I'll second.
Seconded by Representative Connor. And so we'll do a roll call.
Representative Quinn is absent. Representative Connor,
Yes.
Representative Blair,
Yes.
Representative Morris,
Yes.
Representative Matheson,
Yes.
Representative Evans,
Yes.
Representative Barford,
Representative Arford.
Yes. Representative Melorano,
Yes.
Representative Brooks,
Yes.
Senator Stewart is absent. Senator Brenner,
Yes.
Representative Tepler,
Yes.
and Senator Sanborn.
Yes.
11 in favor, 2
Thank you.
absent.
Great. Colleen, can you remind us of the other bill?
Yes, the other one is LD 1636, and it's a bill sponsored by Senator Claxton, which was just recently referred. It is modeled on another piece of legislation suggested by Nashby and it would, it relates to international reference pricing and would require pricing tied to prescription drug prices in Canada.
Okay, so I'm going to propose that we carry this bill over as well. We have not had a public hearing on it. And it is our custom in this legislature to give every bill a public hearing, even those that we may not ultimately support. But this bill came out very, very late and was not available at the time we heard the other prescription drug model bills. And so we did not schedule a hearing for it in time for the end of session. So I'd urge the committee to support a carryover.
I'll move to carry it over.
Okay, Representative Connor has seconded the motion to carry it over. And we'll do a roll call.
Representative Quint, absent. Representative Connor,
Yes.
Representative Blyer,
Yes.
Representative Morris,
Yes.
Representative Matheson,
Yes.
Representative Evans,
Yes.
Representative Barford,
Yes.
Representative Melorano,
Yes.
Representative Brooks,
Yes.
Senator Stewart is absent. Senator Brenner,
Yes.
Representative Tepler,
Yes.
and Senator Sanborn.
Yes.
11 in favor, 2 absent.
Great. Colleen, are we supposed to do table priorities today as well?
I have not gotten that guidance from specifically from the Appropriations Committee. I think it's hard. I think we have a number of bills that you still have recently voted that will have an impact on the table. So
okay,
difficult to do today. That might be something we have to do later on.
Okay. That's
if
fine.
you're comfortable with that. I mean, I know that you identified some priorities yesterday when you were talking about LD 120, for instance, but I don't have a list from the fiscal office, and usually that's what we work from when the committees do discuss their priorities and take some votes and send memos to appropriations.
Okay, I'm going to suggest there's probably going to be time for us to meet as a committee either in person or via Zoom. I think later, whether it's the Friday of next week or the following week. I think there's some time for confirmation hearings scheduled as well. So I think there'll be some window of time where we could convene briefly as a committee. I don't think it's a long list. So just committee, you should anticipate that there may be one more discussion on table priorities. If it's a list that even needs to be discussed, it may be possible to do by email as well. Okay. The last thing I think we have is language review.
I have a few language reviews if you want to go through them quickly.
Go ahead.
And then if you want to discuss the possibility of meeting again for additional language reviews, we can do that. So I'm just going to go through these quick. I pulled them up. I think everybody can see them. Some of them I have fiscal notes back and some of them I don't, but I just wanted to take the opportunity to give you the ones that I have had a chance to draft so far. I have a lot that I still haven't gotten to that I will be getting to the next few days. But this is LD 1494. This is a bill sponsored by Senator Sanborn to create limited line self-storage insurance. There were a couple of technical changes in the proposed amendment that the committee saw when you voted on the bill. The one change that you decided to do at the work session that you didn't have the language on was to establish the fee for self-storage insurance providers. And you indicated verbally at the work session that the initial license would be $100 and the annual renewal fee would be $50. So that's been added to the bill. And then the two additional clarifications related to the definition of location and related to making clear that employees or authorized representatives of self-storage providers don't hold themselves out as other than a limited lines insurance producer, that they, don't advertise that they can do more than provide self-storage insurance. And then it just clarifies that those self-storage providers that are licensed are subject to the fee that I alluded to earlier. So it makes those changes, and then the fiscal information just indicates minor costs to the Bureau of Insurance. Excuse me, not minor costs, minor increase in revenues potentially from these additional license fees, but they are expected to be minor. That's LD 1494. That was unanimous report of the committee.
Thanks, Colleen. I don't think there's questions on that. Committee, just raise your electronic hands if there are questions or concerns on any of these, because I can't see your physical hands while we're sharing.
Great, thanks. This next.
Oh, Representative Evans, go ahead.
Oh, no, my error.
You were just practicing. Okay.
Works though. That's good. LD 299 is the next one. This was also a unanimous ought to pass as amended. This was Representative McCrate's bill that we talked about. The one you saw this language when you voted on it, but the one change that you did do was to remove the provision related to court proceedings and requiring that if a court orders counseling, they need to verify that the counseling will be provided by someone licensed in the state. And you decided, based on some of the concerns that Representative Quinton and others raised, to take that out of the amendment. So that's what this amendment does. Otherwise retains all of the other provisions that were in the concept draft, focused on clarifying the licensing provisions for professional counseling, to make sure that persons may not engage in the practice of professional counseling or profess to the public to be, or assume or use the title or designation of clinical professional counselor without a license. And then it also makes it an unfair trade practice to provide an additional enforcement mechanism for those persons who do represent themselves to the public as social workers, psychologists, or counseling professionals without a valid license to practice. That's LD 299. The fiscal note is in process. I don't anticipate it would have any, that would not have any general fund impact. It would just have a potential impact on the licensing boards. The next one is LD 368. This was sponsored by Senator Sanborn on behalf of the Bureau of Motor Vehicles. This relates to financial responsibility with respect to motor vehicles, and the amendment that the committee made was instead of removing the authorization for corporations to satisfy to the Secretary of State that they have the financial ability to comply with the requirements related to financial responsibility in lieu of procuring liability, motor vehicle liability insurance. This would maintain an exception for corporations that are transmission and distribution utilities. As discussed at the work session, as I understand it, Central Maine Power is the only corporation that is currently using this method, and this would maintain that in the statute. This definition that I've referred to in Title 35A, I wanted to point out, is just specific to electric utilities. If the committee wanted to expand it beyond to other types of utilities, we could refer to another definition, but that's that. I just want to make sure you realize that it's just going to be specific to the transmission and distribution utilities. I don't see any hands, so I'll go on. The next one, this is a minority report. The majority report is ought not to pass. And this is LD 750. This actually, there were no changes made to this amendment from what the committee had seen at the public hearing on this. It was originally a concept draft, but you had the hearing on the bill and the amendment at the same time. The amendment just really quickly makes some changes to the existing provisions in law related to sort of the right to shop program, which in statute is called the Comparable Healthcare Incentive Program. It removes the requirement that small group health plans be compatible with a health savings account. So it broadens the potential plans that would be able to provide these incentives. It changes the amount of the incentive to state that it would be equal or greater than 25% of the difference between the price that the provider utilized and the statewide average for that service. It would expand the available categories within the program to include surgical procedures, and it removes the sunset date of January 1 of 2024. And then it also removes the restriction related to out-of-network providers that's currently in place for only those providers located in Massachusetts, New Hampshire, or in Maine that are participating in Maine Care and Medicare, and it removes that restriction and as well removes the sunset date. Still don't have the fiscal on that, but I don't anticipate that would be anything other than minor costs to the Bureau of Insurance. The next one is LD 751. It's also minority report. The majority report on this is ought not to pass. This was an act to allow employers to shop for competitive health options. This makes some changes to the provisions in current law that allow employers and group policyholders to get loss information or claims information related to their coverage, and then be able to sort of use that information to shop for other coverage through other insurers, and it would allow sharing of that information with both other insurers and insurance brokers. The amendments, the substance of the amendment was in front of the committee when you took the vote had the hearing and discussed it at work session, but the motion made a couple of changes to the prior version. One, it changed this definition here of what a high cost claimant is to individuals whose aggregate claims exceed $50,000. The original proposal had that at $25,000, so it increased that threshold. And then in describing the types of loss information that would need to be provided by an insurer, it clarified that with regard to high cost claimants, insurers would provide prognosis data to the extent that the prognosis would be known. So it clarified that as well. And then the final change, it retains in law the requirement that the insurer did not have to provide loss information for groups that are eligible for small group coverage. So it maintains that in the statute. So that's 751. The next one is LD 1085. This is also a minority report. The majority report was ought not to pass. This is the bill relating to the use of genetic information for insurance purposes. The amendment replaces the original bill, which would have prohibited the use of genetic information for health insurance, life, and long-term care and disability insurance. And what the amendment does is it maintains the prohibition, replaces the current law, which allows use of this information to the extent that it does not unfairly discriminate. But the language in the amendment would prohibit the use of genetic information by insurers in life, disability, long-term care, and other limited type policies. It does maintain the existing provisions that were added last year related to the use of information from 23andMe or other direct-to-consumer genetic testing by insurers. So that's LD 1085. And then the last one that I have for you today is LD 1466. This was a bill originally put forward last session and then brought forward again by the Bureau of Consumer Credit Protection. It made a few changes that you discussed at the work session as part of the amendment. The first is to change the terminology used in the bill. Originally, it referred to digital currency. It replaces that, calls it virtual currency, and then adds a definition of virtual currency to clarify that virtual currency would not include digital tokens or representations used in online gaming or game platforms. And this was an amendment that was suggested on behalf of the association related to electronic online games. That was agreed to by the Bureau of Consumer Credit Protection. So it makes that change. And then the next change was in Part E of the bill that was discussed at the work session. This was, the original provision would prohibit debt collection against consumers for medical expenses if the consumer is eligible or qualifies for free or charity care. Modifies the language somewhat to clarify that if a debt collector has been notified that the consumer is actually or potentially qualified for charity care, then the debt collector may not collect or attempt to collect the debt. And it states that if the notification is provided, the debt collector shall suspend collection efforts until and if they're notified that the consumer is not qualified for charity care. And in that case, they may renew the debt collection efforts. This was language you had in front of you when you took the vote, but it hadn't been incorporated into the amendment. And then the last change is Part F of the bill put forth some provisions related to the types of information that would be required to be filed by debt collectors when they are collecting against credit card and student loan debt, and also prohibited those debt collection actions from taking place in small claims court. And the committee's amendment at the work session, based on a suggestion made by the judicial branch, was to prohibit debt collection actions in small claims court for all types of consumer debt. So this just adds an additional provision in the Debt Collection Act stating that debt collection actions may not be initiated in small claims court. I don't yet have the fiscal information on these last few bills, but I wanted to be able to share, since I had the information, the language drafted, and we had the opportunity to meet in person today, I wanted to share them with you.
Thanks, Colleen. So I'm going to recommend to the committee that we use an email approach to language review for the remainder of this session, with the caveat that if any member of the committee feels that we should convene to talk about the language on a particular bill or identify any problems with the language on a particular bill, that we would convene. So I think Colleen will likely start sending out emails. You'll have 24 hours to respond to them. If you don't respond to them, it's not like the jacket emails where we'll wait for you to respond. It's just, if you don't respond, we'll assume that you don't have any problems with it. So if you want to carefully monitor the language, don't miss those language reviews, because we will report the bills out once they've hit 24 hours in your inbox, if that makes sense to everybody. This is actually the process we usually follow at the end of session, not to hold bills waiting for everyone to sign off on the language review. So this is actually not a COVID procedure, but a normal procedure as we get toward the part where the committee doesn't have regularly scheduled meetings. But we do have a lot of new folks, so I wanted to make sure that people were aware of that process. So Colleen will send those emails 24 hours to flag any problems. If you just have a minor technical glitch, typo, something like that, just talk to Colleen about it. If there's some weird, oh, I need to change my vote, or there's a problem with the language in some way that's sort of more substantive, let the chairs know, and we can make a plan either to meet as a group or whatever needs to happen based on those objections. Okay. Does that make sense to everybody? Anybody have any questions? Darlene?
I was just going to wait for you to be done, but I'm going to get all the bill jackets ready, hopefully tomorrow. And if you want to swing by the Transportation Committee room, you could come in and sign them, and then it would eliminate all these emails as the amendments come in. Otherwise, we're going to be going upstairs to get your signatures as well.
Okay.
Does that
All
make
right.
sense?
Yeah, I think a lot of us won't be in the State House until Wednesday.
Oh, no, I know. I'm just saying when you guys come back into session.
Okay.
Stop in the Transportation Committee room, sign the bill jackets.
Sign them. Okay.
Then we won't have to send you a mazillion emails saying,
okay,
could you respond? Could you respond?
Okay. That's
okay.
Good. Yep. Sounds good. So it's going to be you who will be sort of our stand-in clerk, because we've had a few. We've had Sabrina. We've had a few different folks.
Yeah. It's going to be me. It was mostly Sabrina and I, but you guys decided to pick the same days as transportation to meet. So
got it. Okay, no worries. Great. So we'll look for those paper jackets in the transportation committee room.
yes, I'll leave them on the horseshoe if I'm not in the room, with a big sign that says sign here, and just look by your name and sign by your name. So for the new people.
Right. Good instruction. Okay, great. That's very helpful information as well. It'll be a brave new world starting on Wednesday when we're back in the building.
So what?
I did want to note that I also have a bunch of letters to write that I will also be sharing. I guess by email, as Senator Sanborn indicated. So there are a number of bills where you may have voted ought not to pass with a letter. And so I'll be sharing those, and then the mandate letters requesting the Bureau of Insurance to do the review and evaluation of those proposed mandates that we're carrying over. So you'll see amendments and also drafts of letters, and we'll sort of follow the same process. If you have any comments, let us know. And if we need to meet, we'll meet on those as well.
Yep. Yep, exactly. Okay, great. Well, that wraps up the scheduled meetings of the Health Coverage Insurance and Financial Services Committee. I wish we could have ended on a slightly more happy day, but so it goes. I have already said when we sang to Christian, or all spoke to Christian. I guess we didn't sing to Christian, we sang to Denise. But when we had that goodbye for Christian, I let people know that it is my intention to organize a gathering in person to celebrate our committee and get to meet some of you in person for the first time. At least I suppose we'll meet each other on Wednesday, but certainly my colleagues in the House, I haven't met all of you in person. So we will gather. It'll probably be after we adjourn, unless we're able to sort of pick a day. And sometimes in past sessions, there has been like a day where the presiding officers were like, on this day, we're going to give you a 3-hour break so you can all go have a committee lunch. I don't know if that'll really happen this year, given, COVID concerns and whatever. But I anticipate that after session, we would be able to find a spot to eat outside together and get to know each other a little bit. And we would be inviting Christian and Colleen to join us for that committee lunch as well. Very traditional for us to do that, but we didn't get to do it last year. And I think we didn't do it the year before either. So I'll try and redeem myself by making sure that it actually happens this year. Representative Matheson, go ahead.
Thank you, Madam Chair. As a new legislator, I just wanted to say that I've really enjoyed this process on this committee in particular. I've sat in on a lot of other committees, and I really appreciate everybody that's sitting on this committee, but especially wanted to thank the two chairs who have done an amazing job of organizing, explaining, and been so kind and courteous to all of us that are learning the ropes very fast. So I just wanted to throw that out there and say thank you so much. And I look forward to seeing some of my colleagues here that I haven't actually seen on the other side of the aisle. Representative Connor, I haven't seen you in person yet. I don't know why. But I will make a point of doing that next week so that I can say hello.
All right. Representative Tepler, I think your hand was next.
Thank you, Madam Chair. And what I want to say is to thank everyone on this committee for their hard work. And thank you for the reasonable conversations we've had repeatedly, and the fact that the vast majority of our work is bipartisan. I think that this committee really stands out for organization, but also for bipartisan work. And I appreciate that very, very much. I appreciate that all our conversations are civil, and generally speaking, we're very kind to each other. And I really just enjoy all of you individually and personally, and I think I have met everybody. I I miss sitting on the balcony with folks, including Representative Blyer and I, who had spent some time rocking together last year in the last session. The hard work that Colleen does for us is really, really amazing. And she is a rock star analyst. I watch some of the other committees struggle and they don't have the clarity that she provides us. And she really does an excellent job. And thanks, Darlene, for filling in.
You're welcome.
You know, I saw you a lot when I used to be in tax.
I know. I used to see you every day.
Never see you anymore. So thanks, everybody. And I look forward to raising a glass of Rising Tide beer with you. I think
on the house, I hear.
Well, maybe, I don't know. But
I'll have to be really careful about the rules. So just to be clear.
Right. We might all treat Colleen to her beer.
I think we have a $35 limit or something like that. So we'll have to just be careful about what it is. So
30. It's a $30 limit. I just read the memo.
Representative Arford, go ahead.
Yeah, I just want to say that I can't tell you how many times people in Brunswick that I've talked to have said to me, oh, it must be so hard. It's so contentious, especially between the parties. And I've said, absolutely not. That has not been my experience on my committee, with no exceptions. Although we've definitely disagreed, the parties and within our own caucuses, very much so. It has always been done as respectfully as you could imagine. And not only that, we've had many ought to pass majority reports with us all voting together. And it has been more than a privilege to serve with everybody. And like a few minutes ago, if I have ever in any way said anything that led you to believe that I felt otherwise, I want you to know, please leave it on this screen, because I have so much respect. And I'm really looking forward to us getting together, but I have so much respect for every single one of you. And I'm really sad that Tracy hasn't been able to be with us these last few days, because she's part of our committee.
Okay.
So
thanks, Representative Arford. Representative Connor.
Thank you, Madam Chair. I think Representative Morris is in another committee right now, so I feel like I'm on an island right now. When I look at the screen, I'm the only one. But I did want to say thank you to both chairs. I have never been involved in politics whatsoever. I have never been to Augusta to speak in front of a committee, so this is truly, truly foreign and new to me. And I really enjoyed. Oh, there's Representative Morris. He heard me talking. But I just wanted to say thank you. It has been eye-opening, and it has been very cordial and respectful, and I think fruitful. And so I wanted to say thank you.
No man is an island, Representative Connor. No man is an island.
Very true. Very true.
Representative Evans, go ahead.
Okay, all of you, it's like all my children. I have adopted every one of you. Aww. You know, we
are not old enough for that, dude.
Tax purposes. You know, this is a diverse committee. It's a group of people who are all bright, and we have differing opinions. But what I appreciate about the committee, because I looked at some of the other committees as they were in session, is that no matter how irate we get sometimes, you know, we still end up respecting each other. And I think that's the most important aspect of the whole process. So it's been an absolute pleasure for me to work with every one of you guys. And I look forward to getting to know you all better. And I don't think that I would have preferred to be on any other committee. And Heather, I'm not going to say Senator. Heather, I want to thank you for your leadership, and Denise for your leadership as well. And Stacy, I need to come by your farm. I just want to put you on notice. So, and John and all the other guys. Josh is not here, but we'll see him. I'll pull him aside and we've talked to some of the other people. And Colleen, what can we say about you? So you have done an absolutely marvelous job in getting us to where we are today. So I got to run over to judiciary where I'm not wanted, and and you guys, I've really enjoyed working with you. So bye. Till I'll see you next week.
Yeah. Thanks, Representative Evans. And I'll join you in judiciary as soon as I can. I have to get someone first, though. Okay. And Representative Brooks, go ahead.
Yes, I was going to also speak to my real sincere appreciation for the work that everybody has been doing. And Colleen is really an excellent expert that she's really helped in a lot of ways to help us understand the legislation and to help us along the way. So I really appreciate that. And I also appreciate every member of the committee for your dedication towards helping in many areas. Health coverage is a big one, and other insurance and financial services, things that fall in licensing that falls under our jurisdiction. So I really appreciate everybody on the committee, and I know that we have voted on legislation that has a potential of really saving lives and helping people. I appreciate that.
Thanks, Representative Brooks. Senator Brunner.
Thank you, Madam Chair. I feel a lot like Representative Connor. It's my first session and I hadn't spent very much time in Augusta, and I'm juggling two committees, but I am so grateful for the grace to which you and Representative Tepler have guided us this session. I love our discussions and I love our wins and losses. And I feel like overall we are doing great work for Maine people. And Colleen, the word that comes to mind when I think of you is enlightening. Every time I get your bill analysis, it just blows my mind. And I'm so grateful. I have them all saved in my little file box, my little electronic file box to refer back to. So thank you for all of that thoughtful, consistent work every week. And you guys are always welcome to find me at the farm, and I would happily have you all for the party if that works out. So any day, I'm almost always here. So come say hi if you're in Scarborough.
I like that idea of not hosting the party at Rising Tide, but having it at Broadstone Farm instead. That sounds great. We can have Rising Tide beer there. Okay. So I will just say it's my greatest honor and privilege to be able to chair this committee and to work with all of you. And I know that sounds cliche, but it's true. And I love working with Colleen on digging into like crazy wonky meeting things that put other people to sleep. And so I am really thrilled to have the privilege to sit where I do and to work with all of you on this committee. And I've served on 3 other committees in the legislature now. And I wouldn't give up working with this committee for anything. And we get incredible work done on a unanimous basis more often than not, and work that I think other committees in the legislature would not be able to accomplish on a unanimous basis. So I'm really proud of that, and really proud of working with all of you to get us there, and to my co-chair, Denise, and just all the new members who hit their ground running, even in this crazy Zoom world. I'm just really thrilled with the work that we did this year. So with that, I don't see any other hands up. And so we will sign off. And I don't know if we'll ever use this format again, but here it is. We made it through 5 months of COVID legislature, and I'll see you all next week.
Thank you.
Bye.
Colleen, I'm going to resend you the approval. I put the wrong LD number on the bottom.
Okay.
It's
I'll look for it.
1636. I put 1117 on there twice.
Oh, okay. I'll look for it. Thanks, Darlene.
Okay.
Take care.
You too.